Hello everyone, this is Gilbert Gelot. I'm talking to you here from Private Corporate Counsel. This is Tufts on Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. You can call him at 407-647-7887. Again, that number is 407-647-7887. Or you can email him at stufts@pcc.law. That's stufts@pcc.law. And please don't forget to subscribe and like our channel and our episodes so you can receive more. Hello, Scott. How are you?
Hey, good to be with you.
Good to be with you too. And today we are back in another episode, and we are talking about Connelly case at Supreme Court. What is that all about?
Yeah, so June 6th, the United States Supreme Court issued a unanimous opinion. It's hard to do that. That is going to greatly impact estate planning and business planning and tax planning. It is a decision in which we're dealing with the valuation of a business, family business, closely held business, where the issue is what is the value, the proper way to go about valuing a company when there is insurance in place upon the death of key people in the business. So the facts of the case, generally speaking, look to say, well, what do we do in a situation where you have a buyout agreement that gives the, a surviving brother the right to purchase the deceased brother's shares? If he elects not to do so, let's say that the entity itself, the business entity, has an obligation to purchase the shares. In other words, the business itself must redeem that ownership interest. And let's assume, for purposes of looking at this, that the agreed value of that buyout of the shares was $3 million, and the entity gets that money in from insurance and pays that amount out to the estate. What is the value that the estate is going to list as the estate tax, death tax value for that interest? And so what they did was they said, well, it's got to be $3 million. And the theory is, well, you appraise the business, but then you factor in the money in and money out. And therefore that should be the way that valuation process goes. So in the during the audit, the executor, the IRS audits the matter, and the IRS, the estate fighting back says, wait a minute, we're going to get an independent appraisal, and we believe the value is $3.86 million, which excludes the $3 million in insurance used to redeem the shares, meaning, to buy out the interest. And so the rationale for that is that the life insurance value was offset by the obligation, the redemption obligation. Makes sense. All right. IRS disagrees. They insist that the obligation to redeem the brother's interest, the ownership, does not offset the insurance proceeds that come in. So they value the company at $6.86 million. Which is the $3.86 million valuation, enterprise value as they call it, plus the $3 million of life insurance value. That's a big difference. And, this Forbes article that I'm reading from, that's talking about it, and they say, holy smokes, now this is a game changer in the sense that you're now on notice that this is going to be the position. And next year, if the estate taxes get rolled back, as they're talking about, that there's going to be a reduction in the estate tax. Now, we don't know that for sure, but if the phase out occurs, then we're going to drop right back into the death tax being much more prominently or more likely to be around. And then this is going to kick in where you've got this problem of a lot of businesses that are structured this way with insurance coming in. So bottom line is you got to get to work on this and decide, are you going to look to a different arrangement, maybe the cross purchase agreement type arrangement where the money goes to each other. And, this is going to get into how you best structure insurance and buyouts and these kinds of things. So Connelly represents a big issue and something that we're going to want to take careful regard to in your planning and moving forward. So that's one thing. Number two, you've got to look at the valuation process closely. This is going to come up. And then last but not least, you've got to look at your structure, LLC, corporate models. We've talked about that, what entity choices are made. And so, it comes down to the impact. And one of the things that the Forbes article mentions, which is important, is that they do discuss this idea that a redemption obligation could require a corporation to liquidate operating assets to pay for the shares, which decreases its future earning capacity. In other words, where it can hurt the value of the company. So I'm reminded, Gilbert, of this idea that when you're valuing an interest, it's not what you say it is, it's what it really is. So if you're really valuing a company, one of the things that occurs to me with this footnote and the discussion is how strong is the appraisal and the appraisal that is being done and what methods are being followed in the appraisal process specific to the insurance and its impact on the buyout or the value, I should say, right? Because I see a lot of things where you agree the value is X, but then if you're appraising it and it's Y, X plus Y or X minus Y, then a lot of assumptions have gone into that. So like with everything, folks, when you get into these issues, remember there's more than one appraiser out there with more than one opinion and more than one value. And therefore, when you're looking at how you're going about formulas or language in an agreement on a buyout, take a look also at are you taking the average of 3, for example? Are you taking a fair market value? What is the methodology? What is the details of how you get the appraisal? So that's what we got to do and get that out there. And
is that what we learned from this? Is that what you were mentioning earlier?
Yeah, I think we're starting to realize that, in some ways, and this Forbes article closes on this as well and says it, but between the Corporate Transparency Act with the beneficial ownership interest, with the concern over shell entities, and then you add on top of that this change in the non-competes, at least with the FTC rule, and then you add to that this kind of decision that maybe pushes the envelope a little more on valuation and puts it into estate tax. I think closely held businesses need to get to folks like us, the firm here at Peace per Private Corporate Counsel, because you have to be kind of aware that how you're structured, what are your papers say, all of that is going to be important, especially in the family dynamic where you have generations in the business or potentially in the business. How are you handling that succession plan? So I think up and down, left, right, you've got to be after this and stay on top of the law. All this is happening this year, for example, with these kinds of decisions or things happening. So our audience, again, get on your toes, get to your legal advisors on your paperwork, your shareholder agreements, your operating agreements. You really have to get after it and also make sure they're current. Make sure that you're looking at them from a standpoint. If it's 20 years old, you don't want to be looking at something saying, okay, I think I'm good. I think I'm good. You say, well, you may not be good because there's changes in the law, and then therefore you want your agreements to catch up with the law. So,
and we make sure here, like you said earlier, Private Corporate Counsel, we support businesses and we back them up, and we make sure that they are doing everything correct, and we are here to support them and help them.
Yeah. And that's kind of what we're getting at here. It's like getting a checkup on your car. Go in and look at these kinds of things from a standpoint of is your closely held business where it needs to be? So,
how to make businesses keep falling into these problems that lead to litigation?
Well, and it
seems like a
preventive. So I'd say there's preventative things. Your agreements are trying to anticipate things, deal with hypotheticals and situations you don't even know have hit you. So you have to have agreements that breathe and think and or they don't think, but that handle different scenarios. And then you got to be somewhat flexible and say, okay, but even if that doesn't work, do we have mechanisms to handle the unknown, the unexpected? And you really have to play that all out in your business succession models, your documents, and try your best to handle what life comes at you and what happens with changes in the law even. So look at your amendment. If you have operating agreements or shareholder agreements, what does it say on amendment? Is amendment require unanimous agreement? So you have 10 of you in the business, 9 say yay, 1 says no, you might not be able to amend your agreement. So then what do you do? And so there's a lot of issues that can come up. So.
Okay. You heard him, folks. Just make sure all your paperwork and contracts and agreements are correct, and check with Mr. T. Scott Tufts. If you have any issues or go into litigation, you need a lawyer, an attorney who knows the law, like Mr. T. Scott Tufts. Call him at 407-647-7887, or you can email him at stufts@pcc.law. That's stufts@pcc.law. Visit the website, privatecorporatecounsel.com. You can subscribe and like the channel and the episode so you can receive more. Thank you and have a wonderful day.